about underground regulations in California, looking specifically at the California Code of Regulations, the CCR. In Title I of the California Code of Regulations, there are a number of regulations under the purview that were adopted by California's Office of Administrative Law, OAL. Chapter 2 of Title I deals with so-called underground regulations. And there are 4 regulations in Title I on the topic of underground regs. The first one is 1 CCR Section 250. That is Title I of the California Code of Regulations, Section 250. And it provides 6 definitions for Chapter 2 of Title I, including APA, the Administrative Procedure Act, OAL, again, the Office of Administrative Law. Petitioner is defined as those who file a petition alleging that a state agency has issued, used, enforced, or attempted to enforce an underground regulation in violation of the state's APA. It also defines the terms challenged agency, which of course is the agency or department of the state that is allegedly utilizing an underground regulation, challenged rule, which is the subject of the petition, and what is an underground regulation. Under Section 250A1, Subdivision A1 of Title I of the CCR, an underground regulation is defined to mean any guideline, criterion, bulletin, manual, instruction, order, standard of general application, or other rule, including a rule governing a state agency procedure, that is a regulation as defined in Section 11342.600 of the California Government Code. But it has not been adopted as a regulation and filed with the Secretary of State pursuant to the APA, and it is not subject to an express statutory exemption from adoption pursuant to the APA. Turning next to Title I, Section 260 of the CCR, this concerns the submission of petitions regarding an underground regulation, and it provides that a written petition may be submitted to OAL alleging that a state agency has issued, used, enforced, or attempted to enforce an underground regulation and seeking a determination from the Office of Administrative Law. As a part of the written petition submitted to OAL, the petitioner is required to provide a petition and all required attachments to the challenged agency prior to or concurrently with submitting it to the Office of Administrative Law. Among other things, the petition is required to include the following. First, the petitioner's contact information, then the name of the challenged agency, and a complete description of the challenged rule, as well as a photocopy of the challenged rule, a description of the actions of the challenged agency showing that it has issued, used, enforced, or attempted to enforce the challenged rule. Next, the legal basis for concluding that the guideline, criterion, bulletin, provision in a manual, instruction, order, standard of general application, or other rule or procedure is in fact a regulation, and that there is no express statutory exemption to the requirements of the APA. Next, information that demonstrates that the petition raises an issue of considerable public importance, and the petitioner's written confirmation that the petitioner submitted a copy of the petition and all attachments to the challenged agency. And finally, that the petitioner's written confirmation include the contact information of the individual at the challenged agency to whom the copy was submitted. In turning next to Title I of the CCR, Section 270, it concerns the review of petitions regarding underground regulations. It says that when OAL receives a written petition, that OAL is required within 60 calendar days to determine if the petition is complete. Then, if the petition is incomplete, OAL is required to notify the petitioner in writing what is missing from that petition. OAL will begin the review period when the petition is complete. And OAL will either accept or decline to consider the petition on the underground regulation. OAL will inform the challenged agency that the petition is under review, and OAL will offer to provide a copy of the petition. Within 60 days, OAL is required to determine whether or not to consider the petition on its merits, either in part or in its entirety. Now, while OAL has exclusive discretion to consider the petition, factors considered in determining or deciding whether or not to accept a petition must include the following: the degree to which the petition raises an issue of considerable public importance, whether the issue raised by the petition was or is currently being considered by a court or other body that can address the petitioner's concerns, whether the challenge rule is superseded, whether the challenge rule expired by its own terms, any additional relevant information obtained pursuant to the regulations that is pertinent to a potential resolution of the issues raised by the petition, and the availability of OAL personnel to complete the review of the petition pursuant to the time limits established by the APA. Now, if OAL declines to consider the petition, then OAL is required to immediately advise the petitioner as well as the challenged agency of their decision. And OAL must specifically indicate that their decision in no way reflects on the merits of the underlying issue presented by the petition. On the other hand, if OAL decides to consider the petition on its merits, then OAL must either issue a summary disposition or issue a determination. The circumstances in which facts demonstrate that the challenge rule is not an underground regulation include: the challenge rule is contained in a California statute, the challenge rule is contained in a regulation that has been adopted pursuant to the rulemaking provisions of the APA, or the challenge rule is statutorily exempt from the rulemaking provisions of the APA. If OAL issues a summary disposition, the written document must state the basis for concluding that the challenge rule is not an underground regulation. Also, a summary disposition is filed with the Secretary of State and is sent to the petitioner and the challenged agency within 60 calendar days following the receipt of the complete petition. OAL also has to publish the summary disposition in the California Regulatory Notice Register. On the other hand, if OAL instead issues a determination, OAL is required to notify the petitioner and the challenged agency of their decision and publish the petition in the next California Regulatory Notice Register that gives notice to the public that comments on issues raised by the petition may be submitted directly to OAL. Any public comments must be submitted to OAL then within 30 calendar days from the date of publication in the California Regulatory Notice Register. The challenged agency may submit a response to the petition to OAL. Note that no response may be considered by OAL unless the challenged agency provided a copy of the response to the petitioner concurrently with its submission of its response to OAL. Any response by the challenged agency is required to be submitted to OAL within 45 calendar days of the publication of the petition in the California Regulatory Notice Register. Thereafter, the petitioner may submit to OAL a reply to the challenged agency's response within 15 calendar days after the challenged agency response was provided to the petitioner. Finally, within 120 calendar days, OAL must issue a determination regarding whether or not the challenged agency has issued, used, enforced, or attempted to enforce an underground regulation. Finally, there is 1 CCR Section 280, again, Section 280 of Title I of the California Code of Regulations. And Section 280 concerns the suspension of actions regarding underground regulations. It provides that any action by OAL is to be suspended if, prior to filing its determination with the Secretary of State, OAL receives a written certification from the challenged agency that it will not issue, use, enforce, or attempt to enforce the challenge rule. In this case, OAL will file the petition and the certification from the agency with the Secretary of State. OAL will also publish a summary of the petition and the certification in the California Regulatory Notice Register.